In a medical malpractice case, is there a possibility that after you are questioned in a pretrial deposition, that the defense tells me right then and there, hey, listen, I think we should try and negotiate this case? And likewise, is there a possibility that after I have questioned the doctor whom you have sued in a medical malpractice case, that the defense turns to me right after we finish and said, Gerry, I think we should negotiate and try and settle this case? Would you like to know the answers to those questions? Come join me for a walk around the lake as I share with you the answers to those questions. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. The answers are yes and yes. Now, think about that. You brought a lawsuit against the doctor claiming that he was careless, causing you significant harm and injury. And now, during the course of your lawsuit, you will be questioned by the attorney or attorneys who represent the various doctors and hospital staff that you have sued. During the course of that questioning, they will keep you there for many, many hours. Now, at the end of your question and answer session, which, by the way, lawyers also call an examination before trial, there may be an instance, where the defense attorney says to me after your questioning is finished, hey, Gerry, I think we should talk. We should try and negotiate this case. Now, likewise, during the time I'm questioning the doctor whom you have sued, there is the possibility of the defense attorney afterwards turning around and saying, I think we should start negotiating. I think we should start talking on this case to see if we can try and resolve this. So now you might be asking yourself, okay, under what circumstances would something like this ever occur? Now, I will share with you that this does not happen often. It is not often that the defense comes to us immediately after questioning you and says, you know what? Your client was such a standout witness. Your client was remarkable. There's no possible way we could win a trial. Therefore, we think that we should try and settle and negotiate now. That does not happen very often, and not for those specific reasons. So under what circumstances might something like this occur? Well, when it comes to you, the injured patient, giving testimony, answering the questions put forth by the defense attorneys in this pretrial deposition process, if the defense has already obtained the majority of your records, and if they have already had them reviewed by a medical expert who concludes that the case is not defensible, in that instance, they may recognize at an early point that it would be preferable to try and solve and resolve your case earlier rather than later. That may be a possibility. And when the defense attorney says to me after they are done questioning you that they would like to try and negotiate, I can guarantee you it's not because you, the injured patient, made such a phenomenal witness. That may be only one small factor. But by this point, now we're still at the very beginning stages of your lawsuit. The defense hopefully will have had an opportunity to at least look at the records they were able to obtain so far, and now had a medical expert confirm that they don't have a basis for a valid defense. In that instance, it may be preferable, once they recognize that it is so clear-cut, that the wrongdoing is so clear-cut and obvious that something was done wrong here and that you suffered significant harm and injury, in that instance, that's when the defense would approach me and say, hey, listen, we should really talk about this case. This case needs to be settled now. So let's turn it around, and now we're further along the litigation process. After you have been questioned, weeks or months later, I will have an opportunity to question the various doctors who are involved in your particular matter. After questioning one or more of those doctors, the defense attorney says to me, listen, we've had a chance to review this case. Our expert thinks that we have a tough uphill battle, and we'd like to try and start talking. The problem is, and there's always a problem, there's always a but. What's the problem? We don't have all of your client's records. The problem is, we know that your client is still treating with various doctors. The problem is that we don't know the true value of your client's injuries because she still is undergoing care and treatment, and she's told us during her deposition that she will need ongoing therapy, she will need ongoing surgery to address and correct the problems that she has. So that will affect the value of whatever it is that we offer. And the reality is that that is absolutely correct. And that is why they may hold off and delay entering into settlement discussions if you, the injured patient, are in fact treating and receiving corrective care and treatment. And if that's going to go on for a considerable period of time, then it may be beneficial to you and your case to hold off entering into those settlement discussions. But those are really the only circumstances that I can think of in which the defense would come to us after your deposition or after I have questioned the doctor in his deposition, where they turn around and say, you know what, it's time to talk. we should resolve this case and do it earlier rather than later. But I have to share something else with you. Just because the defense comes to us and says, you know what, we'd like to negotiate this case, do you think that means that they're going to give you every single dollar that you ask for? The reality is no. They're going to fight you tooth and nail on the issue of damages. When they tell us in a conversation, listen, we'd like to try and negotiate, that means that they recognize they have a problem with liability. That means that they recognize that somebody departed from the standard of care, and those departures from the standard of care caused you harm and injury. The question at that point is, okay, how do you know what the full extent of your injuries are? And that is always up for negotiation. If we can show that your injuries are significant, that they are permanent, that they are disabling, that they restrict your activities, and that you will need ongoing medical care and treatment into the future, that will significantly alter the trajectory of our settlement discussions in favor of you, and now they will be forced to recognize that they have a much more substantial case on their hands than they originally thought. Now, you might be saying, are they going to simply accept what we have to say? The reality is no, they're not simply going to roll over and accept what we have to say. They are going to want to see documentation from the various doctors that you are treating with. They will want to see documentation from the various physicians and therapists so that they can recognize for themselves what ongoing problems and disabilities and limitations that you have. So all of that taken together may be favorable for you at an earlier stage. Why? Because now they recognize that they have a problem, and they are reluctant now to go to trial once they recognize that a jury is obviously going to find in our favor on the issue of liability, meaning that the doctors or doctor violated the basic standards of medical care, causing you significant harm and injury. But then the question becomes, can you reach a consensus? Can you reach an agreement on what the true value of your injuries are? And right now, that's an unknown. So why do I share this quick information with you? I share it with you to open your eyes and to help you understand how these types of cases work in the state of New York. You know, I recognize you're likely watching this video because you have questions or concerns about your own matter. Well, if your matter did happen in New York and you have not yet started a lawsuit, but are still thinking of doing so and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.